Y'all, these internet streets been so hot, I ain't even get a chance to come to you about the Queen of Soul. Let me play my intro and then we'll get into it.
Work, work, work. To me, I get work, 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 work. See me do me dirt, 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 dirt. So me for that work, 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 work. When you walk a line, 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 in the cafe, man, da, 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 da. Try me, I deserve it. Let the devil lurking. Yeah. You make a like, now you don't like it. You know I dealt with you the nicest. Nobody touched me in the right. Nobody text me in a crisis. I believe that all of your dreams are duration. You took my heart, all my keys, and my patience. You took my heart, I'ma see for decoration. You mistaken with love, I brought for you for foundation. All that I wanted from you was to give me something that I never had, something that you never seen, something that you never been. But I wake up and nothing's wrong. Just get ready for work, 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 work. To me, I be work, work, work.
Hey y'all, it's Mocha Mima. Welcome back to my channel. Now y'all, the internet streets have been so hot. I've been meaning to come to you with this story, but it was one thing or another. Whoo child. Listen, I'm coming you listen, if it's your welcome to everybody who's here. If it's your first time here, extra special welcome. If you've been here before, thank you so much for coming back. Make sure you all like and subscribe. Click on the bell button for the upload. Y'all, I'm here to talk to you today about the last will and testament of the Queen of Soul, Aretha Franklin. Y'all, now you remember she died in August of 2018. Y'all, I was at work and I had that her funeral playing on my phone. Listen, the funeral was so long. It started playing during the work day. I got off work. I played it in my car all the way home and the whole 9 yards. The funeral was like 8 hours, and I think she had like 6 clothing changes during the funeral. Y'all, and then come to find out, Aretha Franklin did not have a will. Now I know this is common with us black people. We don't have wills. I'll tell you, it's something else. Um, and what ended up happening was her sons went to court. Aretha Franklin has 4 sons. She has, and I'll tell you the names of her sons. She has a son. Her oldest son is Clarence. Clarence at this time now is 68. Clarence is in like a nursing home, and he is under like a conservatorship, so he was not part of the lawsuit. She has a son Edward who is 66, and she has another son Key Cal. I can never pronounce it. Key Cal. Key Cal is 53. Now Clarence and Key Cal were on the lawsuit as, I guess, as the plaintiffs. And then her other son, who is named, he goes by the name of Teddy Richards. He's really Ted White Jr. Ted White was one of her husbands. Now Teddy is 59. Now you're saying to yourself, well, Aretha died. I think Aretha was 76 when she died. Yeah, she was 76, which means, and Clarence was like in his 60s when she died, because I believe Aretha was 12 or 13 when she had him, and then she wasn't much older when she had Clarence. She was very young when she had those 2 children, but she had a lot of help from her grandmother, her aunts, I believe her sister. They helped take care of her, take care of the kids while she was able to work and everything else. Her grandmother's name, I remember, was Big Mama. So Aretha, she had those boys, like I said, when she was very young. So anyway, they sued the other brother because there was a will that was found that was locked in the safe, and that was found in 2010. And then there was another will that was found in 2014. Now, the will found in 2014, There was one, I shouldn't say, all right, the one from 2010 was a written will that was in the safe. The one from 2014 was written in 2014. It was signed in her particular way with hearts and her initials. That was found in 20, I believe it was 2019 in the couch cushions, y'all. In the couch cushions. Listen, my black people. That's all I can say is my black people. Y'all. So the whole thing was crazy. It was just they were in this big battle of who was going to be over the estate to distribute it. I know she had some provisions in her wills where she wanted them to always make sure that Clarence would be taken care of. She wanted to make sure that the boys that 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 wait, let me find it. And I'm reading the art. There's a few articles I have. I have one from NBC News, I have one from People Magazine, and I have one from NPR. So she wanted to make sure that the boys had gone to that uh, Key Cal had gone to classes. The one in 2014 had crossed. All right, she has a niece, Sabrina Owens, and Ted White or Ted Richards, whatever he wants to go by. They were like partial executors on that will from 2010 that they should be co-executors of her estate, and that C. Calf and Edward should take business classes and get a certificate or degree to reap the rewards of the estate. And then that was the 2010 will. But then the 2014 will crosses out their names and puts CCAP in their place and says nothing about the business classes or degrees. Y'all, it's just a whole entire mess. But the jury flushed it all out, and the jury decided that it was just gonna be um, all the 2014 will was valid, and that it was gonna be split up, and that all four of them were going to be allowed to get the royalties, and that the house, I think it's Seacow gets to live in the house. It's just a lot. It's just a lot of stuff. Like there's always going to be royalties and whatnot that's going to come in. That's going to go from them down to their kids and everything, because they're always going to use her music, and everything is going to be constantly used, you know what I mean, in perpetuity probably, because her stuff is, you know what I mean, it's always going to be used. So y'all, it was just it's just crazy. It's just a lot, and I feel sorry for her son that was that is in the home. But at 68 years old, I mean, I'm not sure what happened to him health wise and whatnot. But at least it's he'll be taken care of for the rest of his life. So with that, I also have for you to go along with this Joe Madison, who is on Sirius XM um, radio. He's one of the personalities there. He did an interview with Lou Hutt, who is, I believe Lou Hutt is a lawyer. He is also an accountant. So they were talking about Aretha Franklin's will and what happened in court, and then they also gave some basics about what we can do as the public as far as us getting wills, and understanding some of the verbiage and making it really simple for us. So I wanted to include this in with this video. It is a little long, but it's something that I think that's really valuable for our community, and it's with our people, and it's in language that we could really understand. So I wanted to include that in here for you guys. So listen to it as your leisure. I put it in here so that way you can listen to it, while you're doing, and I always say this, while you're cleaning up, while you're doing other things, you know what I mean? So that way, um, you can listen to it, take it in, let your family members know about it. This video here is not about you liking and subscribing to my channel. It's about the information getting passed on for people in our community that don't have wills, that leave money stuffed under a mattress, or stuck in a shoe or in a boot and all that kind of stuff. We got to get our stuff together. And I'm not saying that to y'all. I'm saying that to me, myself, too, because my stuff ain't totally all the way right. And I need to tighten up on some stuff myself. So, with that, y'all, thank you so much for listening. So, next coming up is going to be the interview with Joe Madison and Lou Hutt over on the Sirius XM network. It is on channel 126, which is Urban View. Joe Madison is Monday through Friday from 6 a.m. to 10 a.m. And Lou Hutt is on Saturdays. I think he is at either 9 or 10 a.m. every Saturday. Lou Hutt gives tips about finances and things like that. So please enjoy the interview, and I will see you in the next video. Thanks so much.
Versus a holographic will, which means it was handwritten. The dates, of course, were different. The formal document was in 2010. The handwritten document, which was discovered by family members under in a couch, right? In the cushions, under the cushions of a couch.
Right.
Some months after the death. But so now you've got a handwritten document, which is 2014, and a formal document, which is 2010. And by the way, Joe, on the handwritten document, you've got written insertions and words crossed out, and it is not signed. Right? Now, under Michigan law, and Michigan law, and I pulled it up because I want to make sure we got it right here. You can have, and by the way, only 26 states recognize handwritten wills. That's another important ingredient. But Michigan is one of those states. But what they require is they say it's valid if dated, so you got to have a date.
Okay.
And the testator's signature appears at the end of the will. Now, that's important.
Meaning that Aretha would have to sign it and date it.
That's right.
Okay, go ahead.
So now, this handwritten document was dated, but it wasn't signed. It only had a smiley face on it. So, Joe, you can imagine. I mean, from a lawyer's perspective, we're like, wow, what a groundbreaking case, to deal with the validity of a holographic.
And by the way, we don't know what she was thinking. We don't know whether she got distracted, didn't know this, and by the way, the other will was locked in a cabinet in her home.
Yes.
Okay.
Yes. And as you say, you get these two situations, and ultimately, and which is not typical in an estate settlement, this went before a jury because this became a question of fact. Judges always decide questions of law, right? But this was a question of fact.
What does that mean? What does that mean to the average person listening? A question of fact.
Well, it's kind of like, I guess a good expression would be, depending on what Joe Madison said, he either intended or didn't intend to leave this car to his nephew. And now what they got to do is hear witnesses and say, or look at other circumstantial evidence to say, well, it could be this or it could be that. And so whenever we deal with those type of situations, generally under the law, we categorize that as a question of fact. When it's a legal statute, then that's a question of law, and
Then
generally
what?
judges will
Then
decide
what
that.
happens if there were? Let me give you a personal example. My father lived in Flint, Michigan. He died. He died decades ago. I was in my 20s. He owned a deuce and a quarter, a Buick deuce and a
I
quarter.
remember that
All
at
right.
225.
220. You got it. At 225, a deuce and a quarter. And he had died. I lived in Detroit at the time. My sister, God bless her, lived in Dayton, Ohio. She actually ended up in Flint. I'm 50 miles away, hour away. She ended up getting to Flint, to my father's house, and confiscated the deuce and a quarter, for lack of a better term, before I got to Flint. Now, no witnesses. I don't know. I don't know if he intended for her to have that car or not, but she was hell bent on getting it. Now, so now
And,
what? So
you
what?
know-
But there was no witnesses. So what? So what? So a
Yeah.
judge then has to make a decision.
Well, yeah, here's what happens, Joe. And and I'm not sure whether your father passed with or without a will.
Without.
But let's assume it's without a will. Now, that is called, when the title ascribed to that is intestate. Someone dies without a will. The way that each state, by the way, jurisdiction, determines what their law is with respect to someone who passes without a will. Because, see, the big question here is, what was the intent of the testator? And so courts, laws, they've always said, listen, we don't want to try to read into what you meant, who you wanted the deuce and a quarter to go to. Put it in writing and sign it. And in most states, they say, have two competent witnesses. Don't depend on us to figure out what you wanted. But if you don't deal with that, if you don't go through that formal process and you pass along intestate, we've carved out some rules. And generally what those rules are, and it applied, by the way, in the Franklin, it would have applied in Aretha Franklin's case if the jury had decided that both of these documents were invalid. What happens then is the state reverts back to this statute. And the statute in every state may say, those who pass without a witness, any assets or properties that remain. And by the way, Aretha had property and she had music rights. Big deal. Just like that deuce and a quarter. Big deal back in the day.
Right.
So what happens is the statute generally will say, if somebody passes without a will, their 50% of their assets go to their surviving spouse, if that spouse is living, and the other 50% is divided equally among the children. Now, again, that's very general because it could vary by jurisdiction. But if I said what is the consensus, the common thread in most of these state statutes is just what I described.
Oh, gotcha.
And so when in this case where, and theoretically, if you had gone to court, Joe, and challenged your sister and her rights to take that car, the court may very well have determined, wait a minute, the deceased passed without a will,
Right.
and let's just assume that was the only asset, they would say, no, Joe is titled to 50% of it. And if you all couldn't agree, if your sister didn't buy you out,
You had to sell the car.
the court would say, sell the asset and split the
And
proceeds.
split it. Got you. Now, now people are probably sitting and say, well, what did you do, Joe? She needed the car more than I did. I mean,
that's a gentleman's heart in it.
yeah, my, here, go ahead, take it. I'm not going to fight it.
But Joe, you can see how passing without a will, it could have created a how would I say this? Bad feelings between you and your sister.
Let me tell you what happened, and it did because he had a house he lived in. We had, and this goes to what you said. No will. I had to sell. I was responsible for selling the house. And everybody, cousins, nieces, nephews, man, I caught hell because I had to sell the house, and everybody was expecting, and we're not talking about a big house. I mean, he worked in a factory, and man, they gave me hell to the point where I just said, you know what? Just show the real estate, just whatever. Just go ahead, because it really ended up creating major tension among everybody. I mean, they all wanted a piece of it.
And see, that is the concern, is that if you pass away without any direction,
right,
it'll be divisive in the family. And so, we're speaking here about passing away without a will,
right,
or putting together a handwritten will,
right.
All of those are very, how would I say this? They're a weak form of documentation. The only reason holographic wills were accepted by 26 states is generally it came up like if somebody was in a burning building. So the threat of death was imminent. They were in a plane about to crash.
Right.
These are circumstances where courts in a lot of states said, well, we got to allow for a holographic will under these unusual circumstances. But we don't prefer that. The best way to do it, and again, going back to your point about a lesson, is to have a formal document. Now, having said that, it's important, as a lawyer, I got to say this. It's important to have professional guidance.
Now, that leads me to...
Go ahead, Joe.
I'm sorry to interrupt, but that leads me...
No,
where is Sam? Sam disappeared. He's on mute here for some reason in our Zoom. Oh, there he is. And let me tell you, I'm reading this story that the pricey Aretha Franklin case teaches a lesson. Pay for a formal professional will. How many ads are on television about these quick wills that cost $99?
Yes.
You see them all. You see them all the time. And
I see Daryl nodding.
Yeah.
It's
been constant.
It's constant. I mean, talk to us about it. And by the way, Lou Hutt's organization, his firm, you guys do family planning. For sake of discussion, Lou handles my children's, like Shauna's will, and my will. Because by the way, I tell you what else I realize I have to do. I've got to upgrade my will because I've got stuff in there about where I want my ashes to be, which, I mean, that's how, but go ahead. Let's start one thing at a time. So what about these quicken wills, man, these quick wills that we see advertised?
Well, there's two things on that, Jim.
Okay.
One is you want a will to be customized. It should reflect various considerations. Like, for example, with Aretha Franklin.
Right.
Her eldest son, Clarence, apparently is under legal guardianship.
Right.
By reason of a mental impairment. See, so that child may have special needs that the other children don't have. There's also, let's face it, in the world that we live, they're blended families. In some instances, two people come together and say, well, wait a minute, I got 2 or 3 kids.
Yeah,
and,
we have a blended
I've been working
family.
For 20 years,
Sherry uses...
and I want these kids to divide up the assets that I accumulated while they were growing up.
Right.
Right? So and then you mentioned another thing, Joe. What kind of burial arrangement? We could talk about organ donations. We could talk about, like is commonly referred to, a life estate, where you say, hey, listen, I want this house to remain intact until, like in case of, let's say, Aretha Franklin, to provide housing for my eldest son who has special needs. Upon at the end of his life, then whatever the equity is can be divided among XYZ. So all of these, so that's one thing, to customize it. The other part is, Joe, is understanding your options. So, for example, if you got minor children, and you say, well, because we know we're all at risk. Every day that we leave our house, we could be in a car accident and not come home.
Right.
The question is going to be, who, and let's say it's simultaneous, husband and wife, or a man and woman in the car. They both, fatal accident.
Or a plane or whatever, yeah.
Or a plane or whatever.
Yeah.
The question is, who's the legal guardian of the minors? And then you got the question of, even if, let's say they're 17 or they're 16, well, they're still not at an age where they're mature enough to manage, let's call it resources, 50,000, 100, 500,000. So do we need a trust to be embedded in the will?
What is the difference between a trust and a will?
Good question. A will creates an estate upon death that is short-term in nature. In other words, it's not this estate, this new shell, and call it a company, was not established for a perpetual existence. It should be in place long enough to compile all of the assets, identify all of those who have rights under the will, typically referred to as legatees, go through a process of review, and then distribute the assets.
All right, and determine who gets what, in essence.
Correct.
Okay, right. Go ahead.
Now, switch it over to a trust.
All right.
A trust is typically a company that we create with the expectation that it will be around for a number of years. Typically, it's set up so that property is transferred to this company. This company preserves that property. They get insurance for that property. They make sure that the property is there's upkeep and maintenance. If it's a stock portfolio, they work with the broker to make sure that there are prudent investments. So they're like fiduciaries, usually for the benefit of someone else.
All right, but everybody,
the benefit of children,
yeah, but everybody doesn't need a trust.
Man, you said it again, right? You, because there are different types. For example, there's a trust referred to as a testamentary trust versus a trust that is set up during life. So a testamentary trust springs into action upon death. Now, typically, if you're going to have a testamentary trust, it's usually for the benefit of minors. But again, as you say, do I need a trust in my during my lifetime? Most people don't.
Don't. Yeah, I got
They
you.
simply don't.
I got you. Daryl, I know Daryl is hoping to win the lottery. That's out there. If he wins, he wants to set up a trust. I mean,
Smart.
You have my phone number in case you win.
Hey, and by the way, let me tell you, if people, Lou is so modest. Lou represents a lot of lottery winners. So I mean, so he's not teasing about that. But I got
That's
you.
true. That's
And
true.
I mean, I got you. Now, all right. So what should people be cautious? What should people be careful when they see these quicken kind of low cost wheels? What should they be? In other words, you're saying be careful.
Yeah, and I'm saying, and you and I are familiar with this adage: don't be a penny wise
and pound foolish. Yeah.
Okay, simply because this is too important. This is what you worked all your life to do. Is you? I mean, I always say, Joe, on my show, I say, listen, most of us we want to. We want to earn enough to have a comfortable life.
Yeah.
Right? And then we hope that we earn enough where we can give back. Right? And then if we really got our game, excuse me a second, I lost my mic.
I got
And
you.
if we really got our game in order, we can leave a legacy.
Now,
Financial legacy.
Now, somebody in this article I'm reading, lessons learned from Aretha Franklin, and this is really interesting advice. I'll ask you whether you agree or disagree. And this is a high price, a New York attorney, who said if you have enough money to leave to somebody, you have enough money to hire a lawyer and not do it yourself.
Absolutely. I agree with that 100%.
Yeah, okay.
And that, the numbers are not important, whether it's $5,000 or $500,000. You want to pass that wealth, those assets on in a non-stressful, orderly, smooth transition. You've got to also, which we didn't mention, Joe, another lesson is who's in charge. See, like you were mentioning your dad. When your dad passed and, your sister made it to the house before you did, the problem is when you don't have a will, nobody is in charge. No one was named as the person to hold the authority. So you end up having to go to probate court and to petition to be named as the person to facilitate the distribution of these assets and to go to court to sort all of this out.
And that's what I ended up doing. Yeah, that's what I ended up doing. And
think about it, Joe, and you all probably dealt with this. In the meantime, there's expenses associated with the house.
Right. Oh, yeah. Yeah, because homeowners insurance had to be paid, electricity had to be paid, house had to be maintained, the whole 9 yards. And by the way, the mortgage had to be paid. This was not a mortgage-free home. The mortgage had to be. I got you. I got you. Wow.
Yes. So that's why when you say folk should make the investment.
Yeah.
Because you're doing this for the betterment of your loved ones who you leave behind. And most of us would agree on this one, Joe. If your kids wake up the next day after you pass away and you say, Mama and Daddy didn't even leave a will, I don't know what to do. They're so disappointed. Now, obviously, they're grieving because of the loss of life, but when, kind of the dust settles, there is a real disappointment. Just like in this case of Aretha Franklin, where you're pitting one son against two other sons.
Right.
And they're probably never going to have a warm, loving relationship from this point forward.
Right.
Totally avoidable. But again, take the time. And Aretha's, to her credit, even though she was very private, she did have a legal consultation. She just didn't finish, right? But again, that's where we run into this dilemma, and we always say that this is such an important, because this is a contract with yourself.
So you, in essence, prepare a will or do estate planning so that the kids won't be fighting after your parents or the parents fight.
You want to maintain the harmony, and then from a legal perspective, you want to be able to. These are your assets. This is your property. You want to be the one to decide how it's distributed. You don't want the state to have to use some formula to determine how assets are split. Mm-hmm. Now, the other thing we should know, Joe, about Aretha Franklin's situation, and the reports indicate that she also had a significant tax obligation, about $8 million.
Whoa. Nobody wants that.
That had to be addressed.
Yeah.
And so, just pulling all of these things together in order to make for a smooth transition.
So what happens in that case? I mean, what happens because let's just take the $8 million. The IRS is not going to go away because the kids are fighting.
That's right.
Okay, they're not going to go away. They're going to get that. And so what happens in that case? And nobody wants to inherit in a will or otherwise an $8 million tax bite.
Yes. So again, because lawyers did get involved in this,
right?
They were able to cut a deal with the Internal Revenue Service where that obligation will be paid back by setting aside a portion of the royalty income, the new royalty income, in the future.
Oh, so because her records are going to be producing income royalties. Got you.
Yes.
Oh, okay.
Yes. So,
all right. I got you. Wow.
But as you can see, there's a lot of pieces, and Aretha Franklin is not the only. We know
Prince,
Michael Jackson,
and Prince.
Unfortunately, you go down the list, and there are a number of people who, unfortunately, made this a back burner issue.
Yeah.
And I think the other lesson that you and I are implicitly sharing with the listening audience is make it a priority. Don't procrastinate about this.
Now that leads me.
We're talking about we're talking, Joe, about a will. Let me give you, if I can, just another document that is of equal importance, and that is a power of attorney.
All right. So what is a power of attorney?
Okay, and here's what happens.
All right.
The will is an ineffective legal document until your death.
All right.
But what happens if you are mentally incapable prior to the death?
Like you're on life support.
You're on life support. So it could be physical incapacity or it could be mental incapacity.
All right, gotcha.
Sometimes, there's a loss of mental acuity.
All right.
And people can't handle, the memory loss, etc. So the question becomes, and this is what the family is faced with, how do we manage mom and dad's resources? Because we don't have legal authority to go to the bank. We can't sign a check. We can't talk to their employer about their pension or their retirement account. So the only way that, and this has happened, to be candid with you, Joe, it happened a week ago. And I have a daughter calling and saying, unfortunately, mom has lost it, and, she's sending money here and there. And Lou, if we don't do something, we're going to be broke.
Right. Okay.
But we didn't have a power of attorney. She didn't execute a power of attorney when she was of sound mind. So these are the little fine herrings, Joe.
So a power
of
that, can I just
Yeah,
I want to support what Lou's saying. That was very important with my parents.
Go
And,
ahead.
you know, I have
Okay.
siblings,
Thank you,
and for example, my brother, I believe, is the executor of the will, and I am the power of attorney. And
Yes.
yeah, they've divided all the responsibilities up, and they've talked to us. Right?
That's interesting.
I mean, even in the last 12 months.
That's interesting. So Sam's brother is the executor of the will. So he's got he determines how we're going to divide. I mean, the will. He's going to carry out the wishes of the will.
That's right.
All right.
That's right.
But Sam has the power of attorney to be able to determine, to be able to get to the documents, the banker, to talk to the insurance company, etc., etc. Okay, is that how I understand it?
And your understanding is correct. But notice, and Sam, in your case, as long as your parents are living, you have that legal authority through your power of attorney. Upon their passing away, your document is no longer valid, and your brother steps up as the personal representative of the estate. And from that point forward, only he has the authority.
Wow, so the power of attorney, I got you. So the power of attorney only applies while the parent or the individual during life. All right. Wow. Now let me.
But upon death.
Yeah. Then the brother. I got you. So now let me ask this: can you be both a power of attorney and the executor of the will?
Wow, Joe, you're always on it. The most important decision. See, most people think the most important decision is the division of assets. Well, that is pretty important. But to me, the most important decision is who you put in charge. In the case of incapacity, albeit physical or mental, or in the case of the management of the estate once you passed away. You're given a lot of legal authority. You're investing that in that person, right? So who you select is key. And then, by the way, let me throw this in. You not only have a primary, but you have a secondary in case that primary person predeceases you.
Mm.
Remember how you said earlier in the conversation, Joe, I need to go back and check my will every 2 to 3 years?
Right.
Because it may turn out that the primary person that you listed as your personal representative has passed away. So we need to update that will.
So then the question Sam is Sam then is there a secondary person, Sam?
Yeah, for my parents, the primary person is the spouse. If my father dies, then it's my mother has all the responsibility.
Okay.
And then it would go to me and then my
you're
brother.
the secondary.
I am the secondary.
Yeah, he is the secondary. Now here's the other question I have, Lou, and I know this is such good information. But let me ask you this. I'm looking at Daryl. Daryl's single. As I know, he only has about 24 children. No, I'm just messing with him. He's single. He has no children. Lives by himself. Right.
Correct.
Should Daryl have a will?
Absolutely.
Really?
Absolutely. Yes. Because once again, Daryl will have assets. And again, I don't care whether the assets 5,000, 500,000, but he's going to have assets.
It might be an insurance policy.
Now, well, you just raised another good issue. So, now, there are certain contracts, and I don't want to deviate, but you just raised an issue about insurance.
Right.
There are certain contracts that supersede a will. So, for example, if I have life insurance and I have a beneficiary clause,
right?
That beneficiary clause
supersedes a
what's in the
will.
will.
I got you. Okay, I got that. All right, that's
Same thing on a retirement account, on a broker's
all right.
account.
So Daryl, let's say Daryl has, because he's a master at being an engineer. So Daryl owns it may be at his house. He has engineering equipment. He owns it outright. Daryl should have a will in order to determine how who gets it.
When it comes to the distribution of assets in a will, you can have specific bequest. Engineering equipment. I want the engineering equipment to go to my mother.
Okay.
And in the event that my mother predeceases me, I want that equipment to go to my sister.
All right.
That's estate planning.
I got you.
Okay.
Yeah. Or I may want to donate it to charity.
Yes.
Okay, gotcha.
Well, and that becomes a point too, Joe. You use Daryl as an example, single, no children, etc. You can bequeath, as it's known. You could bequeath assets to a church, to your alma mater, to the NAACP, to the United Negro College Fund. See, you have that authority. And if you don't exercise it, like in the case of Daryl, let's say he didn't exercise it, then the courts would, again, they follow that statute. They say, oh, he has no children. Oh, does he have any living parents? Oh, he has no living parents. Oh, what about his siblings? See, and that's the progression that it takes when you pass away without a will.
See, I know I follow. Yeah. So I'm sitting up here. I got to tell you, I'm thinking again about these personal experiences.
Yes.
Man, I can tell you this. I'm laughing. I can laugh now. I can laugh now. But Sherry has a sister. This is her they were tight. They were as tight as any sister. And she passed away. And man, woo! Auntie this, auntie that, auntie this. I lost it. Auntie this. Wanted me to have this dress, wanted me to have that coat, wanted me to have that ring. And and once again, this is why there should be a will.
Sure.
Yeah, so and you make it, I think like you say, you customize it. I make it simple. My son, anything dealing with what is male oriented, my clothes, my jewelry, Jason's in charge. That's in the will. So it'll be up to Jason who he's got it. It'll be up to him who he wants to distribute unless the will states otherwise.
See, and you've just come up with a with a clause in the will that is customized.
There you go.
Based on your desire.
And the thing would also apply to Sherry if she wanted to customize her belongings to her, the daughter. Okay,
Absolutely.
I got it.
And Joe, while we're doing this, just one additional document, if I could put this on the table.
Okay.
There's what's known, and let's just call it a health care power of attorney. And the health care, in some states, like in Maryland, is called a health care directive. But what happens is there's a document that we can execute that appoints a person to make a decision about health medical procedures in the event that we no longer can make that decision. Say you're sedated or you're in God forbid, in a coma. And the medical team looks to say, well, we could go right or we could go left. what is your desire? Now, if they have a family there and there's disagreement, and there could be, then the question is, who do they turn to? And if you have a health care directive, goes back to what we said earlier, that appoints someone specifically to make that decision, then you take the medical team out of this dilemma, because now legally they have an enforceable document that says Joe Madison was appointed to make this decision in the event that we have a life and death or life support situation. He has that authority.
Now,
so those three documents: wills, the power of attorney that we just talked about, and the healthcare directive.
All right. Now let me throw this scenario at you. What about what role does a spouse play as it relates to this? Because a lot of people might say, excuse me, I'm the wife or I'm the husband. I'll make the decision. Does that automatically help? Happen?
Again, I love where you're going with this, because you're right. You're right on point. You don't automatically have that right. It's just like if you pass without a will.
Right. Correct.
And Sherry goes and says, "Hey, I'm here at the bank. Joe was my husband. I want to see all the bank records." And they say, "Well, Miss Madison, listen, out of all due respect, we know that the two of you were married, you wonderful couple, love Joe on the radio every day. But having said that, if you're not named as the executor of his estate,
or a joint owner of the account,
that could be another scenario." Okay. Absolutely.
All right, go ahead.
But taking this as just saying Joe has this one account that was was just his own account. Sherry would not have the legal authority
to get
to access that information.
Wow.
Let alone to spend it.
And by the way, now, Ken, I'm sorry. I know I got you going all over the place.
No, you go.
So let's say you have a deposit box. I've heard this. You've got to have permission. Oh, by the way, you got to be careful, because banks don't always have to allow you to get into the deposit box.
You're absolutely right. Let me say it again, as you always say, Joe. Let me put it where the ghost can get it. If you're named as a personal representative, the court will issue letters of administration. You take one of those letters of administration, you go to the bank, you say, "I want to get into Joe Madison's safe deposit box."
Right.
Bank says, "Good, fine." But you go in there and just orally saying, "Hey, I'm Joe Madison's spouse, and I'd like to get into his safe deposit box." Won't go.
It ain't going to happen.
It's not going to happen.
It's not going to happen.
The bank is not going to assume liability, because liability in terms of the damages that could be asserted against them for
for somebody
allowing
taking
an unauthorized person access to their safe deposit box.
Wow. But
and so your general point, and I just want to emphasize this: do not assume because you're a spouse that you have rights, even a spouse. So again, I'm using your example. If you pass away without a will.
Right, correct.
Sherry is not automatically the personal representative of your estate. She would have to go to court. And of course, others may line up to say, "Well, Mom, I appreciate you wanting to be personal rep, but I want to be the personal rep."
Yeah.
See, so you can create all kinds of negative situations.
Yeah, I got you. So that's why you want to have it. You want to have it all spelled out, so that So if something happens to me, if something happens to Sherry or to both of us, it's this sibling or this person. I got you. Now let me say.
Joe,
go ahead.
Let me say this real quick.
Yeah.
So what you and I have just walked through is, how would I say? It's a microcosm of what the estate planning process looks like. See, so again, what you do with a lawyer is what we do is we walk through different scenarios. First, we try to understand the profile of the client. You know, from a career standpoint, sometimes people are in business. We need to figure out how that's going to flow. See, so we look at all of these things, and then if you can think about silos, then under each silo, we try to identify options.
Mm-hmm.
And you present that in discussion with the client. And through this process of conversation and what-if scenarios, you come up with a blueprint that fits Joe Madison.
I got you.
And after we got that blueprint, then as lawyers, we go to work.
And then you go to work. Do you need a power of attorney? Do you need a will? Do you need a trust,
yes.
et cetera, et cetera? Now,
yes.
now, and I think I know the answer to this. Should people shop around for a lawyer? Like for example, I would tell y'all, and I don't get paid for this, but if you're listening, you ought to hightail it over to Lou's firm. But that's just me. That's just me. This is unsolicited endorsement. Now, do you shop around? Because you know somebody will come to you. Somebody may come to. Oh man, I heard Lou. I'm going over to Lou. Yeah. Well, look now. Yeah. Be careful because Lou might say, all right, now here's what you need, and then people say, well, I can't afford that. Then then go shop around.
Yeah. You got the, and I'd say this. And Joe, and sometimes what I say to people is don't look at cost, think about value.
Okay? Good point.
Okay, value is the concept. Do I have an affinity with this person? Do they care? And by the way, are they credentialed?
Yeah.
Do they have experience?
That's right. Just because they've got a law degree.
Communicate.
Yes.
See, because you and I know sometimes you can be referred to a well-renowned, and I hate to get my medical physicians, but I use them as an example. They're world-renowned. Oh, yeah, when it comes to hand surgery, they're the best in the world. But you go in and you talk to them, and all they want to do initially is, they give you the cold shoulder, and then they want to give you some pills, and they don't tell you what the pills or the side effects might be, and they send you home, and they say, if you still got this problem in 6 months, come back.
Hey, Lou.
And you come away and you say, I'm not comfortable with that.
Sherry went through this with her first hip surgery, and wait a minute, and the surgeon, first hip surgery, done, and then we kept talking. We started talking about physical therapy. Oh, you don't need any physical therapy. Just walk. What? And now she's got a second one. Well, this surgeon is. Oh no, that physical therapist was in our home the very next day. And so different experience. So that's I got you. It's about value. Yes. Got you. I got you. Yes. Now here's another question. Should people who are named in the will have a copy of it? And where should I keep a will? Because I've learned or heard and that, for example, do not put a will in a safe deposit box for the very reason we talked about. Because if your name, if you hide that, if you place that will in a safe deposit box, and it's the only copy you've got, you can't get, and you're not on that name on that box, you can't get the will.
Yeah, you're right. You're right. Hey, Joe, that's another part of estate planning. Because different jurisdictions, for example, in some jurisdictions you can file the original with the court.
Okay.
And the court will be the gatekeeper, the safekeeper.
All right.
Right? You mentioned, and I think it's proper, you could literally entrust the original with the personal representative. Now, obviously, that has risk, and the risk is personal representative. God forbid, house burns down, so goes your will, right? So that has a few risks associated with it as well. Or, we can, as you say, we can have a safe deposit box, name, the spouse and maybe one other person, so that they have access in the event of death. But we always want to really keep track of the original. In the absence of the original, so in other words, if you come to, you pass away and, the only copy that, the only document that can be retrieved is a copy, then you sort of get into not quite the complications of Aretha Franklin, but you're going to go, then there could be a judicial proceeding to determine whether or not the court should accept this duplicate as the original.
Wow.
You know what I mean? So, like I say, you're asking a ton of really good practical questions,
Right?
And so keeping that original is key. Now, would I do the? Let me go to the basic thing. Do the legatees, the people that stand to benefit? Do they need copies? No, they don't need copies.
Really? Okay.
Sometimes you don't want them to have copies.
I was just going to say, you really don't want the brother to have a copy, the sister not to have a copy, or people to have copies and then say, well, I'll be damned. He left you this or that. Yeah.
Exactly. They say, Dad, I can't believe Dad has decided to do X, Y, Z for Jim, but he's only going to do ABC for me.
Wow.
So you don't need, they don't have to have it.
All right, got you. Now, let me, another question. Let's say you have your original, you have an attorney create your original will, but you no longer have a relationship with that attorney, or you've established a better relationship. Let's say I went to an attorney, and by the way, I just be straight up. When I was at Radio 1, we did a show. This was before we would do Tax Tip Tuesday.
Tax Tip Tuesday.
You remember that?
Yes,
you know, there was an attorney in the building that was into estate planning. Really nice guy, no ifs, ands, buts. So I went to him. But I'm thinking now, what if I want to change my attorney? Does that mean I need to do another another will with that attorney I want to go to?
You know, again, I'm not just blowing smoke here, but again, your questions, great question. You do not need to change or alter the will because of a change in relationship.
Gotcha.
That becomes an enforceable document, and the enforceability or the validity or the legality of it doesn't change because you no longer work with Sam Sneed, right?
LLC, whatever.
You know, fortunately, the document stands on its own, and as a matter of fact, there are some times where they're not major changes, but they're little tweaks you want to make. Right. And those are they're not called amendments, but they're called codicils.
Okay.
Right? And you can execute a codicil.
Okay.
Now, the important thing
I only got 2 minutes left. I'm sorry.
All right, and I'm going to leave everybody with this is the most important thing on all of these documents that we've talked about. Under each state, the law defines who and how to validate the document.
All right.
So they may say, for example, you have to have 2 witnesses and a notary,
all right,
and signed by the testator. Some states may say you just need 2 witnesses and the testator's signature. So all of these things need to be sorted out,
Okay.
depending on your state of residence.
All right. Now let me end up by doing this for time runs out. I got 1 minute. So if people want to, first of all, your show, you'll be obviously talking about that. What time your show?
Absolutely. Show is 9 to 11 a.m. East Coast time every Saturday.
Okay.
And then we do an encore from 7 to 9.
Got you. All right. Now, if people want to get in touch with you, they can go ahead.
Best way to do it, Joe, is go and leave me a note at louhutt.com.
Okay.
That's LOUHUTT.com.
All right. And I think
Work, work, work. To me, I be work, 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 work. See me do me dirt, 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 dirt. So me by that work, 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 work. When you walk a line, 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 line. In the girl, them hurt, 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 hurt. Try me, I deserve it. Just to have you lurking.
Yeah.
You make a rock, now you don't like it. You know I dealt with you the nicest. Nobody touched me in the righteous. Nobody text me in a crisis. I believe that all of your dreams are duration. You took my heart, all my keys, and my patience. You took my heart, I'ma sleep a decoration.